morning and welcome to our webinar on intellectual management strategies. My name is Pete Matthews and I'll be moderating this session. Before we begin, I would like to familiarise you with the blocks on the right-hand side of your screens. Let me know as I leave your mute in the course of the webinar. If you do have a question, please type it into the same bracket in the toolbox in the please type your question here section. Send this to me and I will pick it up in our Q&A session. I'm pleased to welcome our speaker for today's session, Swapna Sundar. Swapna is the Managing Director and CEO of IP Strategy Advisors. Principal strategic advisory firm, Swapna enables companies and individuals craft and implement strategies, protect and monetize their intellectual property. In April 2016, she published Toolkit and Resources as part of an IPO project entitled IP Smart Toolkit to do business in India. Companies to set up businesses in India and safeguard their IP. Today she will be discussing the challenges surrounding intellectual property in India and formulate successful strategies to validate those challenges. Without further ado, I would like to pass you on to Swapna.
Thank you, Kate. I welcome the participants to this webinar, and I'm really happy to be sharing the IP approach with you. So, thank you for joining us today, and we're really looking forward to guiding you through the toolkit and also learning from you. The toolkit and the resources comprising the IP Smart approach to doing business in India are the outcome of the Accountable Grant Agreement between the UK Intellectual Property Office and IP Strategy Advisors Private Limited. The idea is to guide UK companies to build sustainable IP-led businesses in India and to appropriate value from their IP assets. The two deliverables are the toolkit on the IP Smart strategy for UK companies and the training workshops and seminars on IP Smart strategy. I took this video on the way to work today. The Indian market is much like an Indian street. There is a lot of noise, different kinds of vehicles, not forgetting the pedestrians who walk on the road, because some of the pavements are damaged. And yet there is organization. There is the process that's being followed. And it does take a little getting used to. One thing, however, is clear. The Indian market endures no makeshifts. Paraphrasing John Buchan here, if a strategy is not exactly right, it's vastly wrong. Having lived and worked in India all my life, except for a couple of years in Europe and in the UK, I felt confident in this attempt to unravel the complicated Indian market for IP owners from the UK. Introducing the IP Smart Toolkit. The toolkit can be downloaded on our website www.ipdome.in. You just need to click the UK IPO button and you will be able to see a PDF of the entire document. The toolkit does go a bit beyond mere IP strategy. In fact, it goes into market strategy, ventures into JV and collaboration, and into the drafting and enforcement of contracts. The tagline of IP Strategy Advisors is, at the intersection of the lab, the law, and the market. We believe that an integrated approach to IP strategy requires an understanding of the law and of the market. We also hope that the toolkit would be able to encourage technology partnerships and collaboration between UK and Indian companies. The toolkit is written with the presumption that the reader has a basic knowledge of IPR in India. My book, the IP Smart Workbook, which we saw in the previous slide, would be able to guide you towards understanding the basics of IP in India. The toolkit also highlights the areas in which Indian professionals will be able to guide UK companies. Please do read the resource document, which actually forms the bulk of the toolkit. Understanding the methodology. The toolkit identifies 4 approaches by which IP strategy has been used successfully in India. We ask you in the toolkit, how can these be customized for your company? How can these be aligned with your goals or outcomes? And also, can you reflect on how new ideas may be incorporated with these strategies? We also urge you to work with your sales, production, technology, and IP team to make the methodology work. While there is a technology appetite in India, and the Indian customer is looking for products and services of a global standard, there are young companies that are emerging on the landscape that are as good as any of their global counterparts. Centroid Design Studio, for instance, brings to life any product through their design services, pens, automobiles, medical devices, computer hardware, and even municipal toilets. Ushra is helping thousands of Indians with disabilities to access and use better quality prostheses and orthotics at costs that are reasonable for the Indian market. IPO is revolutionizing private and social computing at the cutting edge of technology and at the intersection of the trend. IPO's products help service providers respond to demands for quicker response times and better management of data and communication. Keeping in mind the reality of the Indian market, it is important to decide on what your precise strategy should be. Consistency in strategy and approach is also essential. The type of company that you are can be determined based on your current IP assets and current resources. Having determined the type of IP company, you need to also know what your strategic goals are in India. These have to be determined on the basis of the skills and growth focus of your company. Having decided on these 2 aspects, we can now customize the strategy based on your resources and goals. The 4 IP type companies that we have identified that are operating successfully in India are based on a classification by a 1973 book by Taylor and Silverson. In the toolkit, these are explained carefully on page 8, where there is a comprehensive table given to understand how typification can be done. In addition, there is a detailed and comprehensive explanation on pages 36 and 37. The characteristics, team size, focus areas, and type of company will determine what type of work you should be doing in terms of your IP strategy. An early approach to IP strategy can be determined by this diagram here. So if you identify yourself as a type 1 company, you may see technology transfer or licensing out of your technology as a very good option. For a type 2 company, a joint venture or development by collaboration for market access could be a good strategy. Type 3 companies embed their IP in products and processes and manage their supply chain closely, while Type 4 companies are massive companies which develop products which improve processes and also have superior resources for prosecution and enforcement along with vendor management and alliances. If you look at page 11 of the toolkit, there are a series of questions. Some of these are there in the next slide. These questions will help you to come up with initial ideas about how to get your strategy alive. For instance, who is likely to infringe your IP? Question 2, is it your vendors or component manufacturers, or would it be your OEM suppliers? Could they be your retailers or even your competitors or consumers? So having determined who might be likely to infringe, on your IP, you can determine what steps can be taken to protect your IP. Similarly, understanding question 4, are your global competitors already operating in India? If your global competitors are operating in India already, then you probably have to take up a stronger IP enforcement strategy. However, if they are not operating in India, then you might look at a type 3 strategy based on what is important for you. The type of company that you are determines what type of IP to focus on, what to do with your current intellectual property assets, and what are the important legal actions for your type of company. The strategy tells you what type of IP will help you to navigate through the different strategies that are available to you and also pick the right one. A type 1 strategy company might be a startup at pre-money stage, an independent inventor, an educational institution with valuable intellectual property assets. Then the strategy that would best fit you would be a type 1 strategy. Focus on market-facing IP such as patents and trademarks. Ensure that the ownership of your assets is protected, and make sure that your co-inventors and management are in alignment with your agenda. If you want to monetize your IP in India, the best strategy would be to license your technology to an Indian entity. Ensure the agreements with the Indian entity are in place before you move your IP to India. In a type 2 strategy, you have greater resources than a type 1 company. Let's say you're a successful research institution, a startup that has received some funding, or an SME starting a new product line. You have presumably some experience in marketing your product in your home country. If so, your IP would benefit from a strategic partnership or collaboration with a similar-sized Indian entity. The Indian entity would provide you access to the market. With their experience, they will be able to negotiate some of the obstacles that you may find difficult to surmount. On the other hand, if you're a type 3 company, you're focusing on technologies, products, brands, and processes. Typically, a type 3 company is a successful SME with strong product portfolios and perhaps a few emerging markets on their agenda. The type 3 IP strategy would require complete and total control over access to the IP. A good example of a type 3 strategy in India is Hyundai strategy in India. Hyundai has very few competitors in its Indian competitors in its segment. Indian access to Hyundai IP is restricted in all areas, including operations, management, production, and sales. Remember, Hyundai is a type 4 company in Korea, but operates as a type 3 company in India. A type 4 company is best described as a super IP company. They focus on product and technology and brand development, global filing and protection strategy, supply chain management, vendor development, and open innovation. Page 44 of the toolkit talks about how Hindustan Unilever, and today Unilever Limited, works in India. Mr. Harish Manwani, COO of Unilever and non-executive chairman of Hindustan Unilever Limited, in 2008 asserted that the belief continues and would continue to be a guiding principle of Unilever. The principle being, what is good for India is good for Unilever. He adds further that the company has earned the love and respect of India by making a real difference to every Indian. The company embraced the needs of the country as its own, and in the process molded and shaped itself to become better and stronger. A type 4 IP company is normally an international, multinational corporation with several products in a crowded market, and they are able to compete not only because of their IP assets, but because of their strength in litigation. When you are forming an IP strategy, you need to ask the questions of yourself. There is a technology appetite in India that you can fill with technologies, particularly those related to manufacturing and automation. Apart from that, you may also want to ask yourself if your own strategies align with the political, social, and cultural goals of the Indian economy. Partnerships and relationships are important. Most of the big companies that are operating autonomously in India have been in India long before India became independent. Integrating a global strategy along with your India strategy is a good idea. You must understand that in India, a long-term consistent strategy works better than a short-term one. Going forward, a UK SME with competency in certain areas of technology and intellectual property, if they find that there is a competing Indian SME industry, a good way would be to work as a joint venture or in a collaborative mode with the Indian entity. Together, the joint entities can operate as a Type 2 company. They will have a stronger say in the market and a better enforcement strategy. If, however, there is no Indian SME, then a UK inventor would better support his inventions with a Type 1 strategy. On the other hand, if an UK SME decides that they are a Type 2 SME, then using their new processes or improved processes in supply chain management and an enforcement strategy, they could either operate as a Type 4 company or a Type 3 company in India. A Type 3 company has less to spend on enforcement and litigation because it's presumed that their supply chain will be able to keep access to their technology very close to the main management in the home country. It is not essential that every Type 1 company should become a Type 3 or a Type 4 company. I have seen this in the market in the last 10 years, that it's not necessary that only a Type 4 company is a mature model of operations or a Type 3 company has a mature strategic model of operations. I would say that it is also possible in India to operate as a mature Type 1 company, which means that you can work on new and essential products that are driving the market and driving disruption in the market, and you can continue to do that on a regular basis. If, on the other hand, you embed technology and process development, then you could operate as a Type 3 company. In page 73 of the toolkit, we go quite deep into the contractual relationships. In India, contract law is quite a bit different from the UK. It isn't in the aspects of litigation and enforcement, but definitely there are areas of contractual relations that need to be looked at when you are coming from another country. For instance, if you look at the parties, parties in India include heirs and successors, legal representatives, but in India, the law relating to families and family-owned businesses of different types are of different types, which means that Hindu families, Muslim families, Sikh and Christian families may have different family structures. Matters of business, inheritance and partnership may differ from community to community. So it would help if you're working with a family-owned business to understand what laws apply to them. Again, it is a good idea to enter into a triple N agreement, which means a non-compete, non-disclosure, and non-circumvention agreement. Quite often we find that the language barrier may be one that is difficult to surmount. We have found that companies that are 60 to 70 crores in capitalization are normally competent in English and can understand and respond in English. However, if you're working in an industrial estate with people speaking in their local and native languages, it may be necessary for you to have your contracts drawn up in the local language. Labor laws and employment laws may be different in India from what they are in your home country, and it is a good idea to hire or engage a local lawyer or an employment consultant who is aware of the Indian market before going forward with your strategy. We're coming to the end of the toolkit and resources. Page 82 onwards, we talk about achieving IP-led advantage lessons from the Indian market. This is an important part in the toolkit. What we understood was that it was essential for us to go and ask the people in the market what their answers are to these questions. Why should one enter India? Why would a UK company want to enter India? For instance, UK companies, the responses include these. UK companies should enter India with their IP only if they find India has a big market for their product. They should be ready to invest time and resources to develop both operations and market. Beyond financial returns, UK companies can also benefit from India as a strategic investment that can yield access to global players and talent in high-end technology. Similarly, in creating core teams or choosing an Indian partner, the answer from the market to this was a UK mid-sized company should seek to work with professional and efficient companies with similar backgrounds. Small Indian companies are sometimes better than large companies with big names who may not live up to their reputation. In some industries, the partner or vendor may already be working with competitors. This would imply that a partner or vendor has the competency and complies with standards required for complex components. Cite 3 Indian companies are looking for technology partners who can provide project implementation of the size of 100,000 to 300,000 US dollars. Indian Type 3 companies are comfortable paying UK vendors according to agreed upon schedules. Similarly, how to create a core team. The core team must comprise medium to high caliber persons. Their training should be UK standard. If they have been recruited from industry, they must be retained in the UK standard. The training may preferably be undertaken in the UK. Training should include demonstration of home country standards, expectations, ethics, and processes. Now, these answers, which we got from the Indian SME community and the market in India, are very relevant. We did think when we were writing it up whether it would strictly form part of an IP toolkit, but we did finally decide to go ahead by including this just because it is so much value and we didn't really want to lose that. So while we welcome you to India and we will be very happy to work in India, we also caution you on some of these aspects and invite you to go through the toolkit. So thank you for your attention. I'm sorry about that. If you really enjoyed the presentation, we've enjoyed speaking to you. Thank you.
Okay, thank you, Swapna, for that detailed presentation. We have a few questions from the audience. One of our attendees is some way through the process of getting their patent granted in India. They want to know if this is in place. Are they still likely to face issues on enforcement?
Okay, so in the last 5 years, the Indian Patent Office has actually become quite professionalized. You can file your patents online and you can get responses online. And to a large extent, the examiners are very friendly and we can always talk to them. They give their contact details, both emails and phone numbers, and you can actually pick up the phone and call them. That said, delays still exist, and I think I would not be wrong in saying that it would a patent grant would take anywhere from 5 to 8 years. As far as enforcement is concerned, I have found in our experience trademark enforcement is easier than patent enforcement. Also because patent enforcement is a little bit more expensive in terms of expert evidences and so on. However, companies have won cases. The litigation process itself is beset with delays, which means that you might be looking at 5 to 6 years in the court in any case.
Right.
Does that answer it?
Yep, thank you very much. Right, I think that's the end of our questions.
Okay.
Thank you very much for your time, everyone. I hope the webinar was valuable to you. If you do have any feedback or comments about today's session or indeed a session that you'd like us to see us do in the future, please feel free to get in touch. Thank you very much for joining us.
Thank you.